Hey everyone, you're watching Lex Rome and today we'll be discussing about the Supreme Court of India. As you can see on your screens, these are all the subjects that we are going to cover today. The introduction of Supreme Court, then we have the organization, appointment, term of office, qualification, removal, जो कि सब article 124 में mentioned है. Then the collegium system and the three judges case with the fourth judges case which is about NJAC. Then we have the jurisdiction and the powers of Supreme Court. So let's get started. Supreme Court is mentioned under the part 5 of the Constitution of India in the chapter 4 from article 124 to 147. Supreme Court was inaugurated on the 28th January 1950, adopted from the Government of India Act 1935. Supreme Court of India is the guardian of our Constitution, the guarantor of fundamental rights. The decisions of Supreme Court are binding on all the courts in India under Article 141. It is the highest court of appeal. It has succeeded the Federal Court of India, replaced the British Council, the British Privy Council. We have an integrated judicial system that enforces both central and state laws. And our Supreme Court also has the power of judicial review, which we can find under the Article 13. Now, the strength or the composition of Supreme Court of India is Chief Justice of India plus 33 other judges who are appointed by the President with consultation of the Chief Justice of India. The collegium system consists of President plus Chief Justice of India, that is CJI, plus 4 senior most judges. The qualifications of the judges of Supreme Court is as follows. First, they should be citizen of India, 5 years practice as judge of any high court, 10 years practice as an advocate of any high court, and a distinguished jurist in President's opinion. When it comes to removal, the judge of Supreme Court may resign in writing to the President or may be removed by an order of President with special majority of both the Houses of Parliament on 2 grounds. First is proved misbehavior and second is incapacity. Now let's talk about the jurisdiction and powers of Supreme Court. First is original jurisdiction under Article 131, where Supreme Court has both original and exclusive power in resolving the disputes between union, that is the central government, and the states, or between 2 or more states, or deciding disputes relating to the elections of President and Vice President. The second is the writ jurisdiction under Article 32, where Supreme Court is the guarantor and defender of the fundamental rights of the citizens mentioned under Part 3 of the Constitution of India, where Supreme Court is empowered to issue writs of habeas corpus, mandamus, certiorari, prohibition and quo warranto. Third is the appellate jurisdiction, where Supreme Court deals with the various matters under various articles, where first is the constitutional matters or the certain cases under Article 132, where an appeal from any judgment, decree, final order of High Court of any civil, criminal or other proceedings is led to the Supreme Court only if it is certified by the High Court under Article 134. Second is the civil matters under Article 133, where cases involving a substantial question of law of general importance and in the opinion of High Court are to be decided by the Supreme Court. Third is the criminal matters under Article 134. If any High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or the High Court has withdrawn for trial before itself any case from any subordinate court to its authority and has in such trial convicted the accused person and sentenced him to death. Next is the advisory jurisdiction under Article 143, which is also known as the consultative jurisdiction, where President consults or seeks Supreme Court's opinion in question of law or fact of public importance or disputes arising out of any pre-constitutional treaty, agreement or covenant. Fifth is the Court of Record under Article 129, where the Supreme Court has power to punish for the contempt of itself and for all other courts. Also, the judgments, proceedings, and appeals are recorded for perpetual memory and testimony. They are of evidentiary value and cannot be questioned when produced before any court, and they are recognized as legal precedents and legal references. Next is the power of judicial review, where Supreme Court can examine constitutionality of any legislative enactment and executive order of both central and state government, and if held ultra-vires by it, it cannot be enforced by the government and will become illegal, unconstitutional, invalid, null, and void. Next is the review jurisdiction under Article 137, which is the power of Supreme Court to review any judgment pronounced or order made by it. Review petition can be filed within 30 days from the date of judgment or order sought to be reviewed and submitted to the same judge or the same bench. Last is the constitutional interpretation under Article 147, where Supreme Court is the ultimate interpreter of the Constitution of India. And that is all for today. Thank you so much.